again for the kind introduction, John, and thank you to you and Germarie and the Environmental Law Association for inviting me today. And I'm really delighted to be here and to exchange about the oceans with other environmental law enthusiasts, but also with environmental law enthusiasts from South Africa. And I know that South Africa has a very close relationship with its oceans because it's geographically located where two oceans meet. And if I'm not mistaken, I think I also see people from Australia in the group, so also a country that has close relationship with its oceans. And the oceans are really a fascinating world, which for legal scholars bring forward an immense variety of different legal issues, so ranging from access to resources, to security, to trade, and even migration. But what I will be focusing on today, which is not surprising because I'm speaking with environmental law people, are aspects of the law of the sea that relate to environmental protection. So in the next 35 minutes or so, I want to address three main themes. So first, I will be giving an introduction about the way in which the oceans are addressed and regulated through international law. Second, I want to look at one of the main traditional activities conducted at sea, which are fisheries, so fishing activities. And I want to look at the problems affecting fisheries, the main actors putting the legal regime for fisheries into operation, and to look at how this whole regime is working. And finally, I want to reflect with you about the current legal regime. So basically what instruments we have and what we've been doing with these instruments so far. And I want to question whether we could use what we have more efficiently. So I will see now if I can share. Yes, great. So you should be able to see now the slides. And I will move you guys there. Perfect. So I will jump right away into the first slides. Please shout if you do not see the slides anymore. So on the slide now, you see a quote from a speech that was delivered by the former UN Secretary General, Mr. Ban Ki-moon, in 2012 during an event to commemorate the 30th anniversary of the adoption of the UNCLOS, the United Nations Convention on the Law of the Sea. And I want to underline two parts in this quote, which are in bold on the slide. So first, the notion of the ocean's interconnectedness. And second, the importance of the sustainability of maritime activities. And I want to keep these two notions in mind as a sort of golden thread throughout my presentation. And this is, I believe, a good way of introducing the main legal regime for the oceans, which is the law of the sea. So it's a set of rules and laws agreed upon by states to regulate their relationships in the conduct of their maritime affairs. And the main regulatory instrument within the law of the sea is, as I mentioned earlier, the United Nations Convention on the Law of the Sea, the UNCLOS. And it's in fact very interesting to note that the law of the sea is one of the oldest branches of public international law. So we're talking about the 1600s, even before. But the protection of the marine environment within the context of the law of the sea is way more recent. So we're talking more about the 1960s, 1970s. And the awareness to protect the marine environment grew because of major environmental disasters, such as oil spills in the 60s and 70s, but also because of the development of new technologies that made the exploitation of resources easier and more accessible. So before marine environmental protection became an official thing, let's put it that way, we had a regime of permission where the exploitation of resources was possible. And then we moved more towards a regime of prohibition. So let's have a look first at how oceans are regulated to understand how different activities, such as fisheries, and the protection of the marine environment fit within that framework. And the Law of the Sea Convention has been constructed around three approaches. So three approaches for the use of the oceans. The first approach is the zonal approach. So basically the oceans are divided into maritime zones, and the convention has different parts in it that address these different zones. And in each zones, the states have different rights and different obligations. So the convention basically tells us what states can do in each zone. The zones are measured always starting from the coastline of the coastal states. And then the closest you are to the coast, the more rights and the more sovereignty the coastal state has. And then the further away from the coast you go, then the less rights and sovereignty the coastal state has. And as I mentioned, in the convention, you really have different parts that target these different zones. So there's a part about the territorial sea, there's a part about the exclusive economic zone, a part about the high seas, and so on. The second approach is the sectoral approach. So the UNCLOS presents provisions that target the regulation of specific activities. And these provisions are either found in the parts of the conventions that deal with the different zones. So for example, it will say fisheries happens this and that way in the exclusive economic zones or on the high seas. But there are also entire parts of the conventions that are addressing specific activities. So for example, part 13 of the convention addresses marine scientific research. And the third approach in the convention is the integrated approach. And this approach acknowledges that the things that are related to the ocean, so activities or actors or zones, are integrated and they influence one another. So remember the quote from the beginning, the interconnectedness of the oceans, the fact that ocean space are interrelated. This integrated approach is not clearly underlined in the convention as it was the case with the other approaches. So there's no part in the convention called integration, for example. So this approach is mostly translated through one main obligation, which is the obligation of cooperation. And this obligation can be found in different places, in different articles in the convention. And cooperation can take place in two different ways. So first of all, a direct cooperation between states. So for example, states need to directly cooperate for the development and transfer of marine technology, for example. But states can also cooperate through international organizations. And for example, states have developed or set different international organizations for the management and conservation of living resources on the high seas. So different areas in the sea, as you can see on the map at the top of the slides, are being managed by different organizations. And similarly, states have decided to cooperate through international organizations for the protection of the marine environment. So once again, different areas in the sea that are regulated by different international organizations for the protection of the marine environment. And this integrated approach mostly relates to the protection and regulation of common interests. And one of these common interests is, of course, the protection of the marine environment. So one question that we can ask ourselves is how these three different approaches to the management and regulation of the oceans can interact. And the example or the case study that I want to use today to explore this interaction is the regime for the management and conservation of fisheries. So I want to specifically look at how fisheries are addressed from the angle of environmental protection. But before we look at what are the actors and the instruments for the environmental regulation of fisheries, I want to briefly have a look at different important problems or threats that are affecting either the fish stocks themselves or threats that fishing activities pose to the marine environment. So the main problem is probably the question of overfishing or overexploitation. So according to the Food and Agriculture Organization, which is the UN agency that deals with food security and fish, more than 30% of marine captures are overfished. So these stocks taken in the wild are overfished, and it can go up to 2/3 of stocks on the high seas that are overexploited. So it's a major problem. Fishing activities can also have negative impacts on the marine environment, so on different habitats and also on other species. So for example, some fish nets are dragged along the seabed, so the bottom of the sea, and then you can disturb some ecosystems there. Other species get caught into fishing nets, such as turtles, but also seabirds. So fishing activities can have impacts on the marine environment. There are also more structural issues, such as the unwillingness or the lack of resources from states to regulate what is happening in their own maritime zones, or also to exercise control over their vessels, the vessels that are flying their flags. And finally, a very serious and important problem with regards to fisheries is the phenomenon of illegal, unregulated, and unreported fishing, so what we call IUU fishing. This is affecting the fishing industry from an economic point of view. It's affecting sustainability and the environment because it leads to overfishing. But more and more in legal research, IUU fishing is being analyzed from the angle of a transnational organized crime. So there's also this new component, this criminal component of IUU fishing that is being explored. So just some examples of current problems affecting fisheries. And if we look at the legal framework, I want to first look at the different actors that are mandated to act under the legal regime for fisheries management, because different instruments then will apply to specific actors. So maybe it's easier to first have a grasp of who are these actors. And there's really a large variety of different actors and institutions, and they also operate at different levels. So the global level, a regional level, but also at the local level. Since we're talking about public international law, the main actor remains states, but in the context of fisheries management and conservation, states can act in different capacities, so they can wear different hats, basically. When they act as coastal states, states can participate in the management and conservation of fisheries through the regulation of their own maritime zones. When they act as flag states, states can act through the control of the vessels that are flying their flags. If states act as port states, they can contribute to the regime for the conservation and management of fisheries through different regulations in their ports. So for example, they could establish additional inspection measures on the ships that are coming into their ports, or they could prohibit the landing of fish that are taken illegally, for example, at sea. And finally, states can act as market states, so through the establishment of trade measures. So they could say, for example, fish taken from IUU fishing will not be sold in our markets. Another very important actor for fisheries management and conservation are fisheries management organization, the regional fisheries management organization, RFMOs. And these RFMOs have the mandate to manage fisheries in a specific geographical area on the high seas. So they have two main tasks, basically. So first of all, they allocate the amount of fish in that region to the different members of the organizations. And they also can adopt conservation measures in their respective area. And these RFMOs are international organizations, so they are formed by different state parties. Also, sometimes the EU can be a party to RFMOs. And these parties are mostly states from the region, but it can also be distant states that have a fishing interest in that area. And then I'm taking the example closer to you guys, which is the Southeast Atlantic Fisheries Organization. The parties or the members of that organizations are first the three coastal states in the region, so South Africa, Namibia, and Angola. But the EU, Japan, South Korea, and Norway are also members to that RFMO because they have fishing interests in the high seas areas in that region. RFMOs in general are very often criticized because they suffer from several weaknesses, if I can put it that way. Some of them include the fact that the allocation of fish that is done by RFMOs is very often established in contradiction to scientific advice. So going against the scientific advice willingly, but sometimes also because they don't have enough scientific data to really make a good decision, basically. So the lack of scientific data is also an important concern. There's also no systematic review process of RFMOs. So there's no overarching authority that can have a look at what RFMOs are doing. There is one review process, but it's not a regular one, so it doesn't happen every, let's say, 5 years. And it's also not mandatory, so RFMOs can decide not to submit themselves to that review process. And RFMOs are very often criticized for the lack of transparency in their practices. So this is an overview of the RFMO. And the last actors that I want to briefly mention, and it's a bit of a special one because NGOs, non-governmental organizations, are most of the time not mentioned in treaties. But for the past decades, the role of NGOs in monitoring and controlling fishing activities has really been growing. And they have been doing that through two different tasks. So first of all, they've been participating in gathering scientific data. So gathering scientific data on the high seas is very difficult because of the vastness and the remoteness of these areas. And very often RFMOs or states do not have the resources to gather the data, so they can cooperate with NGOs on that front. And NGOs have also been involved in direct actions at sea, for the control and monitoring of fishing activities. So maybe you've heard stories about activist environmental groups that are pursuing vessels engaged in IUU fishing, for example. So just a little reference to the role that NGOs play in monitoring and controlling fishing activities. And now I want to look more closely, at the instruments that are forming or that are shaping this legal regime. And once again, these instruments can come from different branches of international law, so the law of the sea, obviously, but also environmental law and even trade law. And these instruments act at the global level, at the regional level, and some of them are legally binding and others are non-legally binding. So we have a wide variety of different instruments. I want to focus for now on the two main legally binding instruments. I see someone in the chat is, oh yes, okay, we will talk about the chat later, sorry about that. So the two main legally binding instruments are, of course, the Law of the Sea Convention that we have mentioned earlier, and fisheries management and conservation under the Law of the Sea Convention are really addressed as one activity or one use of ocean's resources, so an activity that needs to be regulated. We do find provisions in the UNCLOS that ensure the conservation of living resources, but the focus remains on conservation for the purpose of exploitation. So we conserve to make sure that we can continue exploiting. And this is reflected in the main fisheries management objective found in UNCLOS, which is the maximum sustainable yield. So it refers to the maximum level at which a natural resource can be exploited without long-term depletion. The second main legally binding instrument is the UN Fish Stocks Agreement. So this is an implementing agreement under the Law of the Sea Convention that was adopted to complement the framework for fisheries management under the convention. So basically this new agreement complements or brings clarifications to what already exists under the convention. But this agreement focuses specifically on fisheries management of straddling stocks. So these stocks of fish that are traveling or moving between the high seas and exclusive economic zones. And this fish stocks agreement is not perfect, unfortunately, but one positive aspect that it brought is that it really kind of brought in fisheries management many notions of environmental law. Because as I mentioned earlier, the Law of the Sea Convention was adopted in 1982. It was the result of almost 10 years of negotiation. So it was negotiated mostly in the 70s. And as we know, environmental law really had its boom in mostly the late 80s and in the 90s. So many notions of environmental law cannot be found under the Law of the Sea Convention. So these notions have been brought in fisheries management through the Fish Stocks Agreement. And this can be seen in the fisheries management objectives under the Fish Stocks Agreement. So to rely on an ecosystem approach to fisheries, on a precautionary approach to fisheries. And also there's a strong emphasis on cooperation for fisheries management to be done through RFMOs. And under these two main legally binding instruments, there are different obligations that are linked to fisheries management. And most of these obligations are linked to environmental regulations. So this is why I call them environmental obligations. So obligations linked to environmental concerns that need to be taken into consideration when conducting fishing activities. So for example, there's the obligation to avoid overexploitation or overfishing. There is, as we just mentioned, that was created or brought in fisheries management through the fish stocks agreement, the obligation to pursue an ecosystem approach to fisheries. There's also a general obligation or duty of due regard for the rights, duties, and also interests of other states. So basically, you cannot just fish wherever you want and do whatever you want. You need to take into consideration that other people are also fishing or are conducting other activities at sea. And this duty of due regard is very often fulfilled by entering into cooperation with other states. So this is also the next obligation, the duty of cooperation that we have talked about already. There is also an obligation of enforcement, so to exercise an effective jurisdiction and control over your vessels. So this is an obligation mostly for flag states, and they must ensure that their vessels are respecting the different conservation measures in the EEZ of other states, but also conservation measures of RFMOs on the high seas. And there are also general obligations for the protection and preservation of the marine environment. So there's a whole part in the convention, part 12, that deals with the protection and preservation of the marine environment. We could have a completely different presentation just about that. But some of the general provisions under that part are also very relevant for fisheries management and conservation. So for example, a basic obligation to protect the marine environment and to exploit resources in accordance with the protection and preservation of the marine environment. And there's also an obligation of cooperation in that part 12. So we have an overview of what exists under these two main legal instruments, but the Law of the Sea Convention still has its limits. And some of these limits are due to the fact that, as I mentioned earlier, the convention was negotiated in the 1970s. So the knowledge of the marine environment, of the impacts of anthropogenic activities on the environments has evolved, so we know way more about it. And also the fact that environmental law was not as well developed in the 70s that it is now. So there's kind of two treaty generations here. So this is why some basic concepts in environmental law, such as biodiversity or ecosystems or precautions, are not found under the Law of the Sea Convention. So of course, with regards to fisheries, many of these concepts have been included through the fish stocks agreement, but it remains very difficult to understand how they can be applied and enforced in practice. So we can ask ourselves if it is possible to import notions of environmental law within the Law of the Sea to complement what we already have. And my answer would be yes. So first of all, because the UNCLOS was developed as a framework convention. So we always knew that it needs to be complemented and updated with other instruments. And this can actually be done directly through articles in the convention that allow to basically read the convention in light of other instruments. And this systemic interpretation of all obligations related to biodiversity and protection of the marine environment has also been reiterated by many courts and tribunals. So just a quick overview of these other instruments that could be relevant to understand the environmental regulation of fisheries. As I mentioned, these are only global instruments. There are many others that are more at the regional level, for example. But just to have a quick look, so the Food and Agriculture Organization, the UN specialized agency that deals with food security and fish, has developed many legally binding and non-legally binding instruments, including a treaty on the role of flag states for fisheries management, on the role of port states for fisheries management, and also a code of conduct that is kind of the companion instrument to the fish stocks agreement. There are also many conventions coming from nature conservation that address the protection of species and their habitats, and some marine species and marine habitats can be also covered by these instruments. And of course, because I'm talking with environmental law enthusiasts, I cannot forget to talk about important soft law instruments in international environmental law, such as the Rio Declaration, but also the Sustainable Development Goals, especially Goal 14, which addresses life underwater, and targets under Goal 14 specifically address questions related to fisheries. And there's one last instrument that I want to mention, because it's a treaty that is being negotiated at the moment. So the UN is currently negotiating this treaty about the conservation and sustainable use of marine biodiversity beyond national jurisdiction, so the ABNJ process. So it will deal with areas beyond national jurisdiction, so mainly the high seas. And this treaty will not directly cover fisheries, but it will address other issues such as marine protected areas or environmental impact assessments. And this treaty also aims to improve coordination and cooperation between existing instruments and activities on the high seas. So we can hope that this treaty will have some sort of indirect effect on fisheries management. So I'm reaching the part of my presentation when I want to reflect a bit more with you. So if we want to look at all of this, all of the instruments that we have, we could easily conclude that we're all covered, everything is under control, we're all set, all is good. Unfortunately, we're facing a major paradox. So on one hand, there's a lot that has been done. We have a lot of new knowledge, new instruments and processes that have been developed. But on the other hand, fisheries are still considered to be in crisis. So I'm asking myself, what is it that we're not understanding? Why is the search for sustainable fisheries so elusive? And what I suggest is that we're facing this sort of deadlock because we've been hoping to reach new outcomes, but by using the same methods. So the instruments the international community has been developing have had positive impacts. I don't want to deny that, but they still are insufficient. And these instruments are very often based on the same formats, the same actors, the same processes that are very often state-centered. And there's also the question that the law, through its nature aiming for stability and predictability, is sometimes ill-equipped to address complexity, but also constant and rapid changes, which are characteristics that apply perfectly to the oceans and fisheries. So to address these concerns, I'm suggesting to use different starting points. So first of all, to reassess the meaning and use of the notion of interconnectedness, but also to see fisheries first and foremost, not as an activity to exploit resources, but as a socio-ecological system. And how do I suggest to do that? Mainly by using an alternative analytical lens, which is the lens of oceans governance. And governance, I submit, allows us to look broader. So governance is a compilation of institution, actors, rules, science, policy, and law. So law is there, but it's just one component among others. And all of that makes up a framework for an activity. And because of that, governance is a more dynamic process that has potentially more properties to deal with complexity. Because governance relies on new forms of regulations that differ from traditional state activity. It relies on a multiplicity of actors and on the collaboration between these actors. So what governance does is that it acknowledges the existence of multiple layers. And when we transpose this broader lens of governance to look at the environment, at the oceans, and at fisheries, what we can observe is that it impacts the narrative of the law in these fields. So the law is not only a set of normative tools. Governance broadens the toolkits and it realigns the legal oceans discourse around an outcome-based approach to reaching more sustainable and integrated oceans management. And briefly, two policy-based suggestions that I have looked into in my research to try to broaden these toolkits are smart mixes and interplay management. So they're not completely new to the field of fisheries management, but what I want to trigger is more interest to use them more often in fisheries management. So briefly, smart mixes relies on a combination of policy instruments, and it's based on the idea that instruments can be used in combination of one another. So the goal is not to only rely on instruments coming from states or similar overarching authority, but to bring in the mix instruments of other nature, so self-regulation or economic instruments or private standards and so on. So while smart mixes focuses on the interaction of instruments, interplay management focuses on the interaction of institutions. And it suggests that there should be deliberate efforts by states and other actors to improve the interplay between the institutions that are involved. Because with regards to fisheries management, we have the RFMOs that deal with more the management side of things. And then we have other international organizations that are dealing with the protection of the marine environment. So what interplay management suggests is that these two types of organization should more systematically consider the possibility of coordinating their measures. And there have been some limited examples, so there's still a lot of research to be done there, where smart mixes and interplay management have led to more sustainable actions with regard to fisheries management. So for example, the combination of state-based instruments and economic incentives, or the cooperation between RFMOs and private actors, or RFMOs and NGOs, have led to successful results. So briefly, as a conclusion, as a last note, let's say, what I wanted to suggest today is that we have a lot of good tools out there, a lot of good processes and alternative methods of working. But what doesn't seem to work, however, is what we do with all those instruments and processes, the way we use them to ensure that questions of interconnectedness are acknowledged and that cooperation becomes really the default go-to mechanisms when developing new policies. So this is why we need to continue broadening the frame of thinking for finding solutions for sustainable high seas fisheries management by relying on a diversity of mechanisms, even if that might bring international law out of its comfort zone. So I leave it to that. I thank you very much for your attention, and I look forward to the discussion.
Thank you so much, Catherine. Thank you so much. It's been a very insightful. Thank you so very much. I see the very few questions. I think they're about two. So Melanie has asked a question. So I'm going to quickly read the question. And I believe it's directed to you and everybody, Catherine. So Melanie says, I wonder if scientific information is realistically able to tell us what the maximum sustainable yield is or should be with all the changes to the oceans in time of climate change. How accurately are we able to predict the conditions of the marine environment? Put differently, are the existing legal instruments responsive to current ecological realities?
I think this question is spot on because there's definitely a problem with the maximum sustainable yields. And the question of also, is it realistic to hope that we can get all the information we need? The short answer, I would say, is definitely not, because especially on the high seas in areas beyond national jurisdiction, it's so remote, it's so vast. We do not have the resources nor the technology that we need to really gather all the information that we really need. So maximum sustainable yield is definitely not a complete way to go. And this is why these other methods also need to be relied upon. So maybe the precautionary approach would be a good example, because we do not have, as I just mentioned, all the information we need. So we maybe should be careful before taking any actions. Regarding the second part of your question, so are there legal instruments that are more responsive to current ecological realities? Well, this is also something that I explored in my research, that the law is very often reactive in a way. And the current ecological realities and the changes with ecosystems and the marine environment sometimes go faster than the evolution of the law. So we do have problems with more traditional legal instruments to really address these current ecological realities. So yeah, I think it is an aspect of the law, the nature of the law, that it's more reactive and not proactive. So that would be my answer.
So do we have enough current, or do we need to add more legal instruments to what we already have? So we have another question from Vivian. That was just something that crossed my mind because I picked up from Melanie's question, but another question from Vivian. Vivian says, thank you, Dr. Catherine, from climate change perspective, and asking this question directly from the slide on environmental obligations and due regard to the interest of other states. How much is the current framework? For instance, the UNCLOS and the UN Fish Stock Agreement doing to aid or to assist distribution of fisheries to developing countries among most vulnerable to climate change?
Yeah, also a very good question that targets very topical concerns, especially because with climate change, fish stocks are affected. So what happens, I mean, I'm not a biologist or a scientist, but with climate change, there is a warming of the oceans, acidification, so fish stocks just tend to move to different places. So then places where fish stocks were difficultly accessible, sometimes the stocks become even more difficult to access. So the short answer to your question, so how is the current framework really helping that specific aspect? I would say the current framework is unfortunately not doing much. Of course, the questions of the impact of climate change on the oceans have been known for quite a while now. But I feel, and once again, it's linked to the answer that I was giving earlier, that it's also a question of being reactive and not proactive. So I have not, unfortunately, focused in my research specifically on the impacts of climate change and the nexus between the oceans and climate change, but it is definitely something that is being researched a lot in the law of the sea and marine environmental protection. But I would say, and also to address the question about the distribution of fisheries for developing countries, there are some scholars that are, let's say, suggesting that we should move away from the current concept of the freedom of fishing on the high seas. So basically, this is the core concept in fisheries management on the high seas, is that it's basically open to anyone. Well, you would need to nuance that statement with the fact that RFMOs are managing stocks on the high seas. But it's basically based on this notion of the freedom of fishing, which would give an advantage to states and actors that have the resources to engage in fishing activities. But there are some scholars and people that say that we should also see fish resources as a bit the same as the deep seabed, so a common heritage of mankind, or something that belongs to everybody, because fish stocks on the high seas are the global commons. So because of that nature of the resource itself, we should be giving access more equally to everybody. Unfortunately, this is not how the fisheries management regime is currently shaped or built on the high seas. I know, Genevieve Quirk, sorry, I don't want to put you on the spot, but I know you've also looked into that question of like creating more regional oceans organizations. So maybe you have something to add on that front. But yeah, that would be my input on that very relevant question.
Would Genevieve want to add something in that regard?
Thanks, Catherine. Yeah, I guess Catherine's come to a very exciting conclusion with smart mixes and also interplay management when we're talking about cooperation, effective cooperation to remedy what we're seeing happening in our fisheries. And I'm very, very fortunate to look at Oceania and just how effective interplay management has been between the nations of the Pacific, and in particular when it comes to fisheries. There's some tremendous success stories with the parties to the Nauru Agreement and the type of coordination that they've embedded for a long time, working together through effective interplay management. So thanks. Catherine, for the acknowledgement of my work. And I'm so glad to hear more about yours. I'm counting down the days until your PhD is out of embargo.
Thank you so much, Genevieve, for that comment. And I see also Benedict also made a comment, but it related to, she was just merely agreeing with what Melin had indicated, but also adding that we should question MSY as the correct approach to fisheries management. So the other question, it comes from Shemi. Sorry for butchering some of the names, but I'll try my level best to pronounce them as correct as I can. So Shemi says, additionally, what is currently being done to manage IUU in high seas? Because if that's not according to the MSY, won't be adhered to in any case, so hence constant overexploitation.
Yes, indeed, and that's exactly the problem with IUU fishing, because yeah, it's unreported fishing, it's illegal fishing, so it's fishing that we don't know about. So we can indeed not take it into consideration when we establish the MSY and allocate the quotas. So at the international level, the most recent agreement is the Port States Measure Agreement, which is a legally binding instrument adopted under the FAO. It was adopted in 2009, but it entered into force a couple of years ago. And this really targets the role that port states can play to fight IUU fishing. So that's an example at the global level. And it's also quite interesting to see that we're moving away from the more traditional actors at sea, so coastal state and flag state. So we're really looking at states in a different capacity. So that's an interesting development. I would say that most actions at the global level with IUU fishing are taken by the FAO. So they do have a plan of action targeting specifically IUU fishing. I know that some regions are also very active with fighting IUU fishing. To go back to what Genevieve was saying, the Pacific, the region is being very active in fighting IUU. I know in Indonesia, I don't know if there are Indonesian colleagues here, they also have, it's a major problem in Indonesia, IUU fishing, and they have also particular approaches to deal with that. So it is a major problem. It's a very complex problem because, as I mentioned earlier, it has many different facets, so economic facets, environmental facets, but also human facets. So yeah, something to definitely keep in mind when we address problems related to fisheries management, because it's kind of, it goes everywhere, basically, IUU fishing. It kind of falls in the cracks everywhere.
Thank you so much. And Rose has also a question. Rose says, I would like to ask, how might indigenous knowledge and traditional knowledge holders contribute to the changes in international environmental law for the benefit of communities previously and still excluded from ocean?
Yes, also a very good question, and something that is very topical in the current negotiations about the BBNJ process. So this new treaty about biodiversity in areas beyond national jurisdiction. So especially small island developing states in the Pacific and also in the Indian Oceans that are states and communities that are very close to the oceans and that rely a lot on knowledge of coastal communities and traditional knowledge, have been putting forward and have been very vocal about the importance of traditional knowledge for understanding the oceans and biodiversity. So this is definitely a topic that has been at the heart of these negotiations for biodiversity in areas beyond national jurisdiction. I know as well that within the context of the CBD, the Convention on Biological Diversity, traditional knowledge is also being included in some processes for environmental impact assessments, for example. So relying on these, on the traditional knowledge of certain coastal communities to evaluate the impacts that certain activities can have on the marine environment. So these are two examples that I could give at the moment that link the law of the sea and environmental law and the role that traditional knowledge can have.
Okay.
But if you have more knowledge about it, please share. I would be happy to hear more about it.
No, thank you so much for that answer. I thought that was the last question, but then also I think it's Bernadette as well. Bernadette just made a comment, and it's not necessarily a question. She just made a comment that we are learning from science. The challenges are from science to policy, and policy to law. So it's just a comment. But Chemi also asked again, what would it take to legally obligate RFMOs to listen to the scientific advice?
Yeah, quickly to comment on Bernadette's comment, I think it's also very important to take into consideration this relationship or this interface between science, law, and policy. And it's been looked a lot by different think tanks that I've been working with. So the EASS in Potsdam, for example, is working a lot with this relationship between law, policy, and science. The IDRI in Paris, so the Institut de Développement Durable et de Relations Internationales, IDDRI, if you want to look it up. So it's definitely a conversation that is important and that is ongoing. To answer Shami's question, what would it legally take? That's a very good question, because there's nothing that we could do at the moment to force RFMOs to do things. So as I mentioned, there's no overarching authority that has a power to force RFMOs to do things. So RFMOs are international organizations, that are formed by member states. And member states being sovereign entities, they decide what they do with the RFMOs they are part of. So this situation very often leads to deadlocks in decision-making within RFMOs, because a lot of RFMOs have decision-making processes that are based on consensus. So if you have one state that refuses to do something, then the whole measure or the whole process cannot happen. So unfortunately, this is let's call it a frustration that is embedded into how international law works, which is, the consent of sovereign states. So unfortunately, nothing we can legally do about that. Maybe we could, the only thing we could do is to say that the member states within RFMOs, by not following the scientific advice, are going against their environmental obligations. But then there could be a question of causality that would be difficult to establish. So is it the state itself that is not respecting its obligations? Can we pinpoint that particular state, or is it the RFMO as a whole? So we could try it in a future lawsuit, but I think the question of causality might be a problem here.
All right. Thank you so much, Catherine. I see there are no more comments or questions. So, okay. Shemi